Hi, I'm nationwide long-term disability attorney Nancy Cavey. I'm here in Lafayette Park in Washington, D.C., and this is the last of a series of videos that I'll be doing about the new ERISA regulations that went into effect in April of 2018. Now, one of the games the disability carriers has played in the past is the "we're going to exhaust you till you give up" game. What do I mean by that? What I mean is that many times disability carriers will ask for medical information or employer information or other information, and when they get it, they somehow manage to lose it. So they ask for it again and again and again, and this game goes on, and that results in a delay in the determination of your entitlement to benefits. Now, the Department of Labor has said we're not going to tolerate that game anymore. And what they have said is that the disability insurance carrier is going to have to follow the regulations. And if they don't, then the policyholder can claim that their benefits have been denied, even though the claim actually hasn't been denied. It's really called the exhaustion of remedies issue. The ERISA statute and regulations and case law have required that the disability policyholder exhaust all their administrative remedies, which means their appeals, before they can apply. But the reality is that many times disability carriers aren't really interested in making a decision. They just want to delay it and hope that you give up. Now, the new ERISA regulations say that if the disability carrier or the plan have violated the ERISA regulations, that will be the equivalent of a deemed denial, unless the violation is non-prejudicial, not the fault of the carrier, or is a minor violation. The regulations also say that the failure to issue a timely denial will result in the deemed exhaustion, and the policyholder can then file suit. What's great about this is that when the deemed exhaustion remedies apply, the standard of review changes. Now, most policies will have an arbitrary and capricious standard of review, which is not a very friendly review standard for disability policy holders. If the carrier has engaged in this bad conduct and you claim, for example, that they didn't render a decision in 180 days, you can argue that you have exhausted your administrative remedies and that the standard of review is now a de novo standard of review. This allows the judge to substitute their own independent judgment for that of the disability carrier. If your claim has been delayed in a decision, if the carrier hasn't made a decision in 180 days, or they're playing other games with your claim, we might have the ability to argue that you have exhausted your administrative remedies. You owe it to yourself and your family to call me today at 727-894-3188 and learn more about your rights to long-term disability benefits. I hope you've enjoyed this series about the new ERISA disability insurance regulations. I look forward to talking with you today at 727-894-3188 if you have any questions about your rights to long-term disability benefits. Make the call, CAVEY Law.